Once the application is submitted, it's sent within the Patent Office to a specific subject matter group. The Patent Office has thousands of patent examiners. They all have engineering or science degrees of some kind, and your application will be sent to someone who has special knowledge and skill in that particular narrow art. What happens next is your patent is rejected. Claims are almost always initially rejected, and this begins a negotiation process with the examiner, this sort of back and forth argument about what's actually obvious in light of the prior art and what actually is non-obvious in the prior art, and usually involves rewriting of claims and amending of claims to surrender various aspects of earlier claims to what we say to avoid the prior art. This creates a record which, and essentially a file, which becomes very important to the later enforcement of the patent, because what is disclaimed or what is impliedly surrendered in this negotiation process cannot be reclaimed during an infringement case. We'll talk about that in a little bit, but we'll flag that this negotiation creates a file which becomes important in litigation. One thing I haven't mentioned yet about patentability and what can be argued as new and non-obvious to a patent examiner is if the inventor has found a new use for an older invention, right? A new use for an existing invention, an existing patented invention, or even one that has fallen into the public domain due to the expiration of the patent, is in fact patentable. So let's assume that Sally patents a drug for male pattern baldness. So she's patented a chemical formula, a product which helps grow back hair. Pat discovers that the drug cures sinus infections, which nobody suspected before. Nobody thought that this hair drug would somehow be good at curing sinus infections, and Pat's the first person to discover it, and his discovery is non-obvious. Interestingly, Pat can patent his method for curing sinus infections, but he can't exploit it, right? Because he can't make the drug, because Sally's got a patent on the drug. So he's sort of stymied. He can get a patent, and he can get a new method patent, but he can't actually practice it without being an infringer. What's very, very interesting is that Sally can't either. Sally has only claimed the particular drug that she described. She has the exclusive right to sell that particular drug, but it's Pat who has the patent on the use of the drug to treat sinus infections. So if in fact if Pat's invention is valuable, if in fact there's money to be made out there by using this drug to cure sinus infections, Pat and Sally are actually going to have to enter into a negotiation and say, look, there's money out there to be made. You own sort of one half of the invention, I own the other half of the invention. Let's enter into a contract to negotiate, enter into a contract to exploit this new sinus infection cure, and both make some money. This is what's called the case of blocking patents. So Pat's method patent blocks Sally from curing sinus infections, and Sally's product patent blocks Pat from, this sounds like a Dr. Seuss book, blocks Pat from curing sinus infections. And these are almost always resolved through negotiation, right? You might as well, if you're blocked, enter into a contract and make some money.